like to welcome you all. Welcome you all to our August Rules of the Road session. My name is Charlotte Burrell, and I'm serving as the chair of the Administrative Law section this year. The section itself works to improve the administration of justice, and one way we do this is through seeking ways to improve rulemaking. So with that in mind, this Administrative Law section sponsors the Rules of the Road webinars at no cost as a public service. Just a little reminder, you don't have to be an attorney to join the Administrative Law section. On the housekeeping side, as you just heard, this session is being recorded. Then the bar will send out a link to the recording to the webinar to all attendees and to section members within the week. The PowerPoint will be sent out after the session. And we ask that you please save the date for the next Rules of the Road webinar, which will be on Friday, October 9th. And then if you have any ideas for Rules of the Road webinar topics that you'd be interested in hearing more about, please send those to Ann Wall or LaSarah Carter, and I'll drop their contact information in the chat once we get started. For today's topic, we're going to be talking about the exciting topic of temporary rules. The APA allows temporary rulemaking, but provides little guidance on the process. The temporary rulemaking process is significantly different from the permanent rulemaking process, and we need to make sure we understand those differences. So our speakers today will help us to understand this process more in depth. That being said, our speakers are Anna Vard Choi, who serves as General Counsel and Executive Director of the Licensing Board for General Contractors, and was previously in private practice representing several different boards. And Ryan Mittagey, who is an attorney who represents independent occupational licensing boards. On a final note, before we get kicked off, if you have questions during the session, please submit them. I'll be monitoring the chat box and I'll feed them to our speakers as appropriate in terms of the flow of the conversation. And with that, I'm going to turn it over to Anna and Ryan to kick us off.
Thank you, Charla. It's a pleasure to be here today with one of my former colleagues, Ryan Mittagey, who also continues to provide the board with legal assistance. But we are both very happy to be here today. Though I was teasing Charla and Ann Wall earlier, I said, could you have given us a more challenging, difficult, not very exciting topic, such as temporary rulemaking. And but we hope after today that you at least take a few things. We don't expect you to remember everything about this process because it is very different from permanent rulemaking. And I hope we have some rulemaking coordinators on here. But if anything, it's just nice to know that you're not in this alone. But just I'll briefly finish introducing myself, and then I'd like for Ryan to introduce himself. But I've been a practicing attorney here in Wake County in Raleigh for 32 years. And actually was a rulemaking coordinator back in 1995 for the Office of Administrative Hearings. Yes, they have rulemaking coordinator too. So the process has changed quite a bit over the years, but I've stayed in the process, also having served on the Rules Review Commission a few years ago. So Ryan, introduce yourself and then we'll get started.
Yeah, of course. And thank you, Anna. I've had the pleasure of working with Anna for several years now. So I've actually learned quite a bit from her and look forward to helping provide some of that to everyone here on the call today. Though I have to disagree, this is exciting stuff, and don't you dare say otherwise until we're done with the call, at least. And the nice thing with the temporary rulemaking, just like anything else in administrative law, it's written down support. And that is in 150B, and that's where we're going to take a deep dive into today. So as Anna said, I am in private practice, work with several independent occupational licensing boards, and look forward to sharing some of the stuff I've learned so far with you all today.
Sounds good. Ryan, who will you be navigating through the PowerPoint or?
thinking I could take that on.
Wasn't sure. Okay.
Can you see that slide, Anna?
I can, yes. All right. So let's get started. And I do want to repeat one thing that Charla said. If anyone has any questions, please put them in the chat. The last thing that Ryan and I want to do is to lecture to everyone for an hour, because I'm confident that if we turned on everybody's microphones, there'd at least be a few people snoring. So Ryan, do you want to go ahead and get moving on to, yes.
And I think that to at least give everyone an idea of where we're going to move today, and it is mostly just right through the statute, because with exciting information like this, that's the best way to do it is take it from top to bottom. So the purpose and context, just generally understanding what a temporary rule is and why it might be promulgated, and going through some of the requirements that you're going to need when starting things out with your magnificent journey on temporary rulemaking. Going to the RRC and the requirements and notice and comments and hearing requirements, statement of findings, and then obviously some of the further implications following the promulgation of your rule. So, which hopefully happens very quickly for everyone.
Well, and one of the things I would like to mention before we really dive in is if there's any takeaway, especially for those of you who are rulemaking coordinators or maybe are somewhat new to rulemaking, this is a complicated process. I think, in my opinion, it is more difficult to navigate because it is mostly counting business days and not calendar days, but not for everything. And so making sure that when you get to the end of the process, that you have counted correctly is really important. And if you are not a details person, it is okay to find someone who is and say, will you check behind me? I can tell you when I was in private practice, I spoke with one of Ryan's colleagues and said, here is the flow chart, here are the days, here are the calendars. Can you please check behind me? So I just want to give everyone grace. If it is hard, in my humble opinion, it is unnecessarily complicated. I would love to see it match more of the permanent rulemaking process, but just shorter. It doesn't. So we have to navigate it, but it is hard, and it is okay to have a colleague check and recheck your dates and everything, because you do not, just with permanent rulemaking, you do not want to get to the end of the process and realize that you have goofed up a small piece of it, because while rules review can approve a rule where there has been substantial compliance with the process, that is not guaranteed. So, Brian, you want to go back to the slides?
Yeah, and that is a really good, important point, Anna, because the whole point of this process is a temporary rule, because there's circumstances that require it. And we'll go through those circumstances and why it's necessary to move into temporary rulemaking. But the important piece is doing it right the first time, so that it doesn't negate the entire point of the process, which is to get a rule out there quickly. So temporary rulemaking, you can see here, it allows an agency to create a rule immediately based on certain circumstances. Well, not immediately, or quickly based on certain circumstances, but at least immediately start the process. So it's expedited, but it's not outside of rulemaking. There is a difference between the permanent rule, temporary rule, and emergency rules, and we'll go through some of that here today. But there are specific statutory grounds as to why you need to complete the process in the correct way and move forward through that. And it does go through RRC's review. And of course, it's for a limited duration, which is the point of it being a temporary. So temporary rulemaking is not a substitute for permanent rulemaking, and you can't just use it in order to speed up your timeline. You have to be able to create the temporary rule based on specific circumstances. And the circumstances are generally, though they are listed out in 150B, is generally statutory changes. So you are looking at the General Assembly promulgating a rule for your specific agency that's changed everything. And your rules go against what the law now is. So you need to be able to change those rules quickly so that your regulated public are able to comply appropriately, and that the board or agency is able to comply appropriately as soon as possible.
Right. And I think, Ryan, you mentioned that earlier we've got permanent and emergency rulemaking. This chart really shows, sort of lays out the differences between the three different types of rules. Again, you have to have a reason to, a specific reason to be moving through the temporary and emergency rulemaking process. And you may, if we're talking about temporary rules, you can see down the bottom right, you may actually also be going through the emergency rulemaking process, because when you're going through that, you have to be moving through temporary rulemaking. But not always. You can start the temporary rulemaking process and never have to worry about emergency rulemaking. But you should also be keeping the permanent rulemaking process in the back of your mind, unless the temporary rule is truly only going to be needed for a temporary time period. So this chart just sort of lays out the differences. You've got to have some reasons. The public process in terms of notice, it's ordinary for permanent, it's shortened for temporary. There is no prior notice for emergency. The codifier plays a bigger role with emergency rulemaking. And again, duration. Permanent, it's there unless changed or sunset or repealed. Temporary, the maximum amount, and we'll get into the various aspects of that, is no more than 12 months after the effective date, but emergency rules are much shorter. All right.
And a lot of it really flows down from that basis for the requirement of the rule, or what the instigating event, why you're creating this rule. If you need a permanent rule, then the process flows from there. If you need a temporary rule, then the rest of the standards kind of come from there. Of course, an emergency rule it's quick to get something in place as needed.
Okay.
But we'll get into temporary rulemaking specifically. So an agency can adopt a temporary rule based on their requirement because current rules are contrary to public interest, or there's an immediate need for an action based on statutory grounds. As we said, the law may have changed, or the requirements of permanent rulemaking would be contrary to public interest. If you're having to go through a long permanent rulemaking process, then it may get in the way of public health and well-being. But making sure that your statutory grounds and your reasoning for creating the rule before initiating. And that's going to come into play later because it's going to have to be known. You have to document it. You're going to have to provide the reason for the need and be able to show why it's necessary for this temporary rule to be created now, instead of going through the longer but more detailed permanent rulemaking process.
And our next slide actually does provide or list the different types of grounds for immediate adoption. Ryan, can you move to the next slide? Yes. And again, as he mentioned earlier, it's typically the most common reason that you are going to be thinking about temporary rulemaking is because of a recent change. Matter of fact, sometimes where there will be express authority in statutes to say, the agency shall, keep an eye out for that, shall implement temporary rules to comply with this new change. So that's a situation where it's not necessarily the agency's choice. The General Assembly has instructed you do need to go through temporary rulemaking, because an agency may think, well, there's been a statutory change, but we're good with just taking this through the permanent rulemaking process. We don't want to navigate this. Well, do keep an eye out for instructions that you may have to go through temporary rulemaking. But as you can see, It's when there's recent change to federal or state budgetary policy, change in legislature. There's also quite a number of agency-specific requirements. So I would take a look at 21.1A just to make sure that your agency isn't in one of those. All right, next slide. So there is a period of time by which you can't pursue. In other words, it's sort of, you can't pursue a temporary rule. In other words, it's presumed that that immediacy, that urgency, if you've waited more than 210 days, then you must not have needed it. So, a temporary rule has to have not only the reasoning for it, but there's a timing issue. And the triggering event, whether it was a court order, whether it was a change in the law, whether it is any of those other topics, must have occurred and or become effective. Again, we're talking about the laws, no more than 210 days before the submission of the temporary rule to rules review. And I think this is a really good practice pointer here. So when we're saying the temporary rule to rules review, it's not the initial filing. It's the initial filing, the public hearing, the comment, and then to rules review. So again, if there's a change in the law, you need to sort of, just as you would for permanent rulemaking, work that schedule backwards and make sure that you're able to put things in motion so that you can meet those, the time frames, again, most of them being counting business days and not calendar days, and get it to the Rules Review Commission no more than 210 days. And again, that rules review, just like with permanent rulemaking, you file with OAH Rules Division, but then at the end of the process, before the 20th of the month, you file with Rules Review. That's what we're talking about.
Yeah, and that is very important, Anna. And the idea is that if it's been 7 months since the General Assembly has created a law, well, why haven't you done anything? Why do you need a temporary rule now? Why is it so emergent, or why is it that you need a quick change to your rules right now if you haven't done anything for the last 7 months?
Right.
And then it goes back to that, as you said, you kind of backtrack from there. Generally 30, 40, 50 days. So you're looking at 6 months of just sitting on a rule before you start your temporary rulemaking process. And RRC is going to look at that and say, well, why now? Why do you need a temporary rule now and not just go through permanent?
Right. Now, the next slide does reflect that the commission can waive that 210-day requirement. However, if we have any rulemaking coordinators on here, I am sure you are aware, and has been the case for many years with the composition of the Rules Review Commission changing, not just the current group of folks, that they are loath to grant waivers of any type. So yes, you can request it, but the old adage where sometimes it's better to ask for forgiveness than permission, I don't think that really applies to the Rules Review Commission. You really should keep an eye on that deadline. And so, unless there are extraordinary circumstances that require you to request the waiver, because you may not get it. You're asking for permission. And again, if you've got an agency where the rulemaking body, in the situation with my board, their regular meetings are only quarterly. I know some occupational licensing boards that only meet, at least one that only meets twice a year. That's a problem with this schedule. However, there are such things as special meetings. And fortunately, most of us have learned to at least have some level of proficiency in virtual meetings. So that may be what is required in order to position your agency so that you don't have to ask for this permission, because there is no guarantee you're going to get it.
And definitely bring your receipts ready to show as to those extraordinary circumstances, because they're going to be asked for. RC is not just going to, like Anna said, let these waivers run through. And special meetings exist for a reason. So definitely be ready if that happens, or be ready to go through permanent.
Okay. So now we're going to kind of just start talking about just sort of the general process. So first of all, at least 30 days before the adoption, it has to be, the notice of public hearing has to be submitted to the codifier. And one thing I do want to mention, we're going to be talking about two OAH forms. The first form that you are going to file is the 0700 form. When you go farther down in the process, I believe the next one is the 0500 form. Yes, you are filing the higher number form first. That I one time had to reach out to Rules Review and I went, am I looking at this right? I filed the 700 form before I filed the 500 form because I kind of thought it needs to be the other way. And they were like, uh-huh. So it just wasn't intuitive to me. Numbers should be sequential, but I just wanted you to know that if you ever were thinking, wait a minute, why am I filing the higher number form first? But then you are, after the publication, you have to notify persons on your interested persons rulemaking list, accept written comments, and conduct a public hearing. So these are just sort of, and I think when you look at these without the flow chart that is going to be in the next slide, you're like, holy cow, we got at least 30 business days. And that's something you see in this process that's different than in the permanent rulemaking process. The at least, within, it's different. It flows differently than permanent rulemaking. So that's why it's really important to keep double checking your timelines.
And that's something that's going to be a theme throughout the presentation, is double checking and timelines, knowing what numbers go where and when. Those 30 days, business days before adoption, having 5 days after publication, 15 days before adoption, things like that. That's where we keep saying is really pay attention to your dates and know what type of calculation you're doing.
And before Ryan moves on to the next slide, I want to point out something. If you notice, submit and publish at least 30 business days, 5 business days, notify interested persons, 30 business days, written comments, 15 business. But then look at the public hearing, 5 days after publication. So that's a calendar day. You can count 1, 2, 3, 4, 5. So I just, again, there is some inconsistency. I'm not making a judgment or value statement. There are inconsistencies in how you count the days, which is another reason you need another set of eyes on counting temporary rulemaking. So this slide, it may be a little hard to read, but the good news is this slide is the flow chart that is on the RRC's website. If you go to OAH rules and then go to information for rulemaking coordinators, they have this is the flow chart that is there. They have one for permanent rulemaking. They also have one for emergency rulemaking. I find this is very helpful because when I have to go through temporary rulemaking, I'm writing the dates out beside, like if I'm working back, if I know that, okay, I've got to start this temporary rulemaking process. And let's say I have a regular business meeting coming up for my agency on October 21st. And so I know that they can adopt. So then I have to sort of count backwards and go, do I still have time to start, or if I were to start today, would that not be enough time? And so, but anyway, I think this flow chart is very helpful in helping you figure out if you have enough time in between regular meetings.
Well, and for me, I love a good map and a good checklist, right? Being able to go through and say, check, I did this on this date. And you can pin it right up to your board and say, all right, this is the date I did this, or start from the end and go back up and say, all right, this is when it has to be done. These are my deadlines moving up, and there's plenty of white space on it. So you can draw all your lists and things like that and make sure it's done the way that you're needing to have it done.
Yep.
And here's the timeline.
All right.
So as we keep saying, kind of coming back from the day that you want it adopted and moving back towards your first filing of the rule. So, we have from day 0 forward here, but submit the proposed rule. And as Anna had referenced, to the codifier, which would be Form 500 or 0500. And notify
Then in that case, I may have been wrong. I thought 700 went first. But anyway, if you have any questions, you can ask OAH. Yeah, I thought, my apologies for saying that it was 0700 that went first.
Well, and Anna and I were saying the same thing and preparing for this is if you do have the questions, ask OAH. They are very receptive. They're extremely helpful. And while we think we know a thing or two about this, they are extremely knowledgeable. Every interaction that we've had with OAH has always been very helpful and very insightful. The people over there are there to help out agencies to make sure that things are done appropriately. And there's no hiding the ball. They want to make sure that it's done the way it's supposed to be done. And they're very, very good at their job. So shout out to OAH and for no other reason than to just say that they do the right thing. So
no, I mean, truth be told, if you don't get it right, they're going to call you out on it, but that's not their end game. They want to answer the question. They want to help with the process. Good. Looks like Ryan Collins provided information on the forums in the chat. So we appreciate that, Ryan.
Shows back up. And Ryan was nice enough to help us out in the last rules of the road. So I'm glad that he's shown back up and keeping us straight here. Yeah, so this is kind of your timeline, your roadmap. Again, very similar to the last chart, but it is nice to at least have something to visualize. So you are, this practice point, if you need a temporary rule, plan several months. Though it's temporary, though it goes a lot quicker, you do want to make sure you're in this planning stage early, making sure to jump on getting your initial submissions for the rule done quickly. And make sure you have your timeline set out.
I would say one of the things that was just hardest for me to wrap my head around is once I have a schedule set and you've got the no less than 5 days, well, then I know that, on day 6, I can do this. I always build in 1 extra day. At least 30 business days. Okay, well then I count to the 31st business day. The big variable, and it's not really a huge variable, is actually at the very beginning of the process with that down pointing bullet, the within 5 business days. The codifier posts the proposed rule, the hearing notice online. So if you're trying to build out before you even file anything, and you're trying to build it out, you don't know when the codifier is going to post the proposed rule. They have within 5 business days because things are triggered by that. You see the before adoption, hold a public hearing not less than 5 days after publication. Well, you don't know when they're going to publish. So practice pointer, assume that they are going to take the whole 5 business days. I think, I don't do temporary rulemaking much, and I think they usually take less than 5 business days, but the law gives them 5 business days. So assume they're going to take it. That'll, it may be that you could have done things a day or 2 earlier, but that way you don't have to go, oh my gosh, I need to move things because I assumed they would only take 3 business days. They took 5 business days. Just assume they're going to take 5 business days because they can. All right. Ryan, anything else you wanted to mention on? Okay, good. Calculating dates.
Go
Talk
on to
about
date.
dates.
And this, as we've mentioned several times, this can be tricky, as counting business days. Business days are Monday through Friday, and they exclude holidays. Weekends and days that OAH is closed are not counted. This can be tricky, because it's based on OAH's schedule, and generally that's based off this Office of State Human Resources. But you can also verify. I'm counting out this many days. I see it's 4th of July. Is that a 2-day holiday or a 1-day holiday? And making sure that you know exactly how many days you have, because again, miscalculating a day in the beginning of the process will make it a huge headache at the end of the process when you have to restart the whole thing. So ask the question, and it makes it much easier to show that you're willing to learn and understand what's necessary early on, and then go by that, instead of having to come back after and restart the whole process.
Well, and I'd like to just, again, sort of a practice pointer. So let's say you're going through the temporary rulemaking process in, September. And North Carolina sometimes gets hurricanes in September and October. And I remember, again, this is many, many moons ago, but I remember when Hurricane Fran came right through Raleigh, again in August or September, it's probably in September, and state government was shut down for a week. So if there's any event, especially weather-related event, that you believe has, like if you hear that there's a state of emergency, or there's something going on in Raleigh, or big blizzard or hurricane or something like that, like is at the bottom of this slide, confirm with the codifier. I don't know whether that would affect the counting of the days. I do not know, especially when now that we have technology, that even if people can't move around, if there's power, that people can still do business. So when in doubt, contact rules review. But again, a practice pointer I would add on top of that, and I think this is just sort of how you communicate. If you're asking a question of the codifier, rather than saying, is such and such counted as a business day? Tell them, let them know that you have looked into it, and say, I know that I should be, or I assume I should be, referring to the State Human Resources Division, the Office of State Human Resources for holidays. However, because of blah, 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 in other words, show them that you have been thinking about it, not that you're just asking them to spoon feed you information. I think they would appreciate knowing that you've done everything you can, and that you're not trying to waste their time because you just don't want to look it up, that you truly have done what you could to figure it out and you just aren't sure. That'll go a long way.
Well, I agree, and I think that being able to provide them the context as well, just as we said, they're not trying to hide the ball. You should be transparent with them, because it really doesn't benefit you at all to hide anything. Say, hey, we want a rule to be promulgated at this date, and I'm seeing that Labor Day's coming up, or Christmas, or whatever it is, and I want to make sure that we're within our timeline. You can't ask them to calculate the dates for you. That's not their job. But you can say, hey, all of this context, is this a holiday, or does this count appropriately? Can you confirm that I have the right thinking here? And that context can be really helpful. But also don't assume that they're going to do your job for you, because they're there and they have a lot going on here as well. So making sure that you are as helpful to get the answer that you're looking for, or an answer to your question, and make it easier on them.
Before we move on to the next slide, just a comment from Ann in the chat. I'll read out loud just if others are listening and not following on the chat. and if you want to respond to that at all. But in fact, at the last RRC meeting, one of the commissioners specifically said she opposes waivers. There have been occasional waivers granted, but they're really for serious reasons. Example, an occupational licensing board with only one staffer who'd been hospitalized for something along those lines.
That's spot on. I think it was probably about 10 years ago when I was on Rules Review Commission. And I mean, the commissioners collectively didn't love them at that time. It didn't mean that they were not going to grant any waiver, but it had to be for an extraordinary circumstance. So again, that's why we are not suggesting that you follow the old adage of it's to ask for forgiveness than permission. It is better that you just get it right the first time.
And that's probably why we have the dates up here so many times in this slideshow, is making sure that if you want to screenshot, get a checklist, whatever it is, to figure out how you need to go about this, and double checking the statute to see exactly what's required of you. It's really best to do it on the front end.
All right.
So the written statement of need, or explaining need. You want to take it, Anna?
Yeah, sure. So, and again, I apologize. I think I was thinking about another rulemaking process, but so the Form 500, the statement of need, we've talked about, you can't go through temporary rulemaking unless there's a reason to go through temporary rulemaking. And, you know, the primary structure of temporary rulemaking is you've got permanent rulemaking and you've made everything shorter. You've made the process shorter. You've made the public notice schedule shorter. The window in which a public hearing can occur, everything is shorter. And so all they're saying is tell us what your rationale is and why you need this, because why you need to avail yourself of a process that gives the public less due process. I mean, that's really what it's about. And I think it may be on a yes, I'm not going to jump ahead, but you need to be specific. Don't just say because there's a recent change in the law. Explain what that is. So Ryan, anything you want to mention on this topic?
That's why that is, so what the law is, what it does, why it affects you, connect those dots. Don't make people search or wonder, why is this necessary? I mean, it's not on them to figure out why it's necessary. It's on you to explain why it is necessary.
Mm-hmm.
And as well as if there is any fees, rules establishing fees or increasing fees, there are separate processes, making sure you're going through the appropriate reviews. And one note here is the statement needs to be signed by the head of the adopting agency, not the rulemaking coordinator. It could be the same person, but the head of the agency, not the coordinator. And that is significant to make sure you're doing that on the front end.
So that's going to be a board chair, a commission chair, maybe an agency secretary is not going to be the staff person who is the rulemaking coordinator, unless that chairman, of the rulemaking body, that chairman, that secretary also happens to be the rulemaking coordinator. That's really important. All right. So again, this is sort of a practice tips, and they're not necessarily looking for a 300-word paragraph, but give them what they need to say yes. Give them what they need to approve this. Explain, pursuant to House Bill 123, which was ratified on such and such a date and signed by the governor on Y date, comma, the way that this agency has been dealing with X is now required to make a certain type of change and blah, 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 blah. it is in the public interest that we provide guidance as quickly as possible. I mean, it may affect hunting. I'm just thinking hunting, fishing, um, all sorts of things. I'm sure everybody here has different examples. For us, it could be how general contractors become licensed. We have 31,000 people who need to know that. So, Ryan, any other thoughts on drafting effective findings?
Yeah, exactly. I think that one of the biggest ones is there's a change in law, and your rules say the opposite. Your rules are telling people to do something completely different. You have to change it immediately. The regulated public cannot comply with both the law and the rules. This is why it has to change. And in making that extremely clear, I think that's the another theme of the presentation is making it your needs clear, and providing that to RRC to make it easy for them to.
All right. And again, this slide just hits on what we've been saying. Don't summarize, give the why. Don't give just the what, but give the why. And so this just reiterates what we just said.
Temporary rules, increasing fees. Again, there's additional steps to be taken. So if it does increase a fee, the existing fee requires separate compliance with you need legislative authority would be helpful. But there is a 90-day provision. The commission does not meet to hear the consultation within 90 days after the publication. The submission of the request and the consultation requirement is satisfied. But the consultation requirement goes through GovOps. The agency has to submit for consultation, requesting on the same date the notice of text be published. The report must state the current fee, proposed new or increased fee, statutory authority for the fee, detailed explanation of the need. And if you don't do it, then there's consequences to your rule.
Well, and the takeaway on this is with GovOps, my experience has been, I don't know when I've submitted even through permanent rulemaking, submitted a fee increase where GovOps ever met. So my agencies were always availing themselves of that. If they haven't met by 90 days, consider it approved. Keep in mind that process may be longer than your temporary rulemaking process. So it means you might get to the end of your temporary rulemaking process. And again, I think it's possible. I haven't laid it out, but if you get to the end of that process, you might be close to 90 days. But if you're not at 90 days, you can't start charging that new fee unless the GovOps has met and said thumbs up, or in absence of a meeting that 90 days has passed. So I'm just letting you know they may not be aligned. With temporary rulemaking, they're probably going to be closely aligned, but just watch out for that. It may only be a matter of days, but it still could matter. So after adoption, so much like the permanent rulemaking process, agency votes, notice, public comment period. Typically, you would also have a hearing, and then agency votes to adopt. Same process, just different schedule with temporary rulemaking. So after adoption, the agency submits the adopted rule, signs the finding of needs. And what's interesting is that the commission has to review it within 15 business days, which means it is possible that the review occurs outside of the typical RRC schedule. I think in the past, I kind of did the machinations where I was like, I don't need it to be 2 days before, 3 days before a meeting. I can figure out how to land it within a meeting, because certainly if the within 15 business days occur, if there's a rule, an RRC meeting, then that's when it's going to be reviewed. Brian, anything you want to mention?
It can land in between those meetings. So knowing that, but RRC will ensure that it's reviewed within those 15 business days, and they have a mechanism for that as well.
Okay. And so when rules review is looking at it, they're going to look at it similarly to how they look at a permanent rule. Is there statutory authority for what the agency's trying to do? Is it clear and unambiguous? Is this temporary rule necessary to implement or interpret? And was it adopted in accordance with procedures? I see in a comment that, and I'm guessing because I think it's happened to me too, Ryan. Ryan was saying that he had a temporary rule that fell in between two meetings, and if didn't see the rest of the comment, but I'm guessing it maybe was like a few days before, and they asked, "Hey, would you mind if we just put it on the agenda for the upcoming meeting?" Is that what your comment said, Ryan?
I have that here.
Okay,
And
great.
yeah, the regular meeting falls within 15 business days, making sure that that's an option and asking
Yeah.
for considering a delay. And
Yeah.
I'm sure Mr. Collins was more than appreciative and able to do that for them. So, but yeah, as Anna said, the commission still goes through those same steps. I think that they've always been clear as they're not looking into the substance of the rule and as to whether it's a good rule or not, but they're looking at the authority that you have to provide it. Is it clear? Is it ambiguous? Is it necessary to implement? And is it following the necessary procedures? So I know I've heard that from the RC several times. We're not looking to see if it's a good rule or not. We're looking to see that's done appropriately, and that's this entire process.
Right. So the next slide deals with how to deal with a rules review objection. Again, if you are familiar with the permanent rulemaking process, this again, it'll feel a little bit like that, but you just got a shorter window of time. Your first option is to supplement. If you can, I would do it. I'm sure the biggest challenge is timing. I know for me, especially when I was in private practice, I would, and sometimes the staff attorney will make suggestions, but you're not sure what it is that will make them happy. And so I might have a suggestion, but I need to run it by my agency because what I think makes sense may not make sense to the agency. And so again, it's a shorter window of time. And so you might be kind of like, I need to get somebody on the phone. But you can supplement. But you don't have to. And just like with permanent rulemaking, is it a technical change that they want you to make, or is it substantive that would lead to an opinion?
And then if choosing not to supplement, there is that declination, and just choose not to move forward. If you do nothing for 30 days, it's seen as a declination to supplement. And then of course there's judicial review through Wake County Superior Court after the rules are returned.
So effective date. And that was
Before you
something
jump into that, Anna, I just want to know, Anne had made a comment about fees.
Mhm.
And acknowledging those. So I don't know if it's just additional information, but with regard to GovOps and fees, just a reminder to always check the budget. There's often a provision that you don't have to follow GS 12 3.1 if the fees is authorized in the budget, and gave reference to section 5.1 of the current budget for an example of that language.
Exactly. Usually when my experience when having to go through GovOps is not a statutorily mandated fee, but it's a fee that's going to be changed in a rule. Because if a fee is set, it's set. You don't have to go through GovOps. And this is a topic for another day, but there's a big difference between saying an agency can charge X versus an agency can charge up to X. Because if the statute says up to X, then they have not set the fee, and that needs to be set in a rule. So, But getting on to the effective date, as Ryan said at the very beginning of the presentation, the maximum period of time, as you can see on the left column, 2 deadlines to calendar. Either this rule is going to vaporize 270 days after the register publication or 12 months after the effective date. And one thing to note is it's not 270 days after rules review approves it. It's after it's published in the register. Again, if you're a rulemaking coordinator, you know you've got the register publication schedule already. So your 270, and again, I mentioned this only because it'll just help you with calculating, dealing with that permanent rule, because this temporary rule is going to go away. And so it might buy you a few more days that you may need.
Exactly. And making sure that you're pulling that out. And as we said in the very beginning, if you're going through temporary rulemaking, you should also be going through permanent rulemaking. Because the whole point, unless there's not a need for a permanent rule in place, that you only need it for 270 days or 12 months, but it's not a very common circumstance. So making sure that permanent rulemaking is also going through it. A lot of the time, you're already doing half the work by going through your temporary rule. So being able to pull those same things over and doing that dual process. I believe for emergency rule, there's the requirement if you're doing an emergency rule to also have a temporary rule. For temporary rule, it's suggested that you have a rule going in place.
Well, and Ryan mentioned one thing. I think sometimes one of the more challenging parts of the process, if you haven't had a pre-review, is drafting what you think is a really well-written rule or amendment, and rules review staff taking a different opinion. So you got the lawyers here laughing because we're very proud of what we put down on paper. However, if you have gone through that with the temporary rulemaking process, and they're saying, hey, you need to move this here, you need to change the shall to will, or will to shall, and change the gender and do blah, blah. And you've gone through that with temporary, guess what? You might be 99% there for permanent rulemaking, which is kind of nice. So
yeah. And as an aside, right, there are rules to that. I think everyone knows that there are rules to how you write your rules. Take a look at that on the front end and make sure that you've brushed back up on, especially if you've gone through permanent rulemaking a long time ago, or you did your PRF review, but you haven't really looked at the recent rules for writing a rule from ROC. Definitely check that before you jump into this process, making sure that you are tight on your rules. So there's not a lot of those technical changes, if you can.
So we've got about 5 more minutes and just a few more slides. I want to leave just a couple of minutes for some questions. Our next slide deals with judicial review by an aggrieved person. So judicial review is available in this process. Ryan, did you want to mention anything?
No, just similar to any other judicial review for any other rulemaking. You have the option, but the hope is that it's not necessary as you go through the process. But the option is there.
So our next to the last slide is common failure points in temporary rulemaking. And again, I think that the first one, when the triggering event does not fall within statutory ground or falls outside the 210-day period. A number of years ago, I was filing initial rules for an occupational licensing board, and I filed them as temporary rules. And the question was there was something that led to, did I meet, sort of when I started it, did we meet the 210-day period? Fortunately, collectively, rules review felt that I did, but there were several commission members that said, no, you need to be counting from this date and not that date. I think it was Oh my goodness. I think it had to do it had to do with when the agency sprung to life. And so it was just I say that because I've been on the receiving end of, did you start the process in time? So always be conservative when you're trying to figure that out. Um, Also make sure that you're not just saying, well, we need temporary rules because General Assembly gave us this new statute. Give them the why. Again, it's very much like when I say you're asking a question of the rules review staff and you explain, well, I have this question and here's how I've gotten here. Same thing. We're requesting a temporary rule. It is because this change affects this and affects this, and therefore. Ryan, anything else you want to touch on this sort
Yeah,
of?
I think we've gone through most of all these things today, but it's, those calculations, the fees requirement, repeating statutory language if necessary, but also that permanent rulemaking is too late. If you go through your temporary rulemaking and you sit on your permanent rulemaking, you might have an expiring rule, and then a permanent rule, and you're going to have a gap there, and is just a big headache as to the consequences of that. So,
Well,
and
that
that's it.
is it. That's it for us. I appreciate the comments that we've received. Are there any other comments? I see Anne has given a practice tip. It says regarding codifier entry of rule into code, check the OAH website. What does the remainder of her comment say?
There have been times when OAH publication staff have been short-staffed and a lot of rules entered into the code, and no matter how hard they work, they may not get a rule entered in the code as quickly as you might think. So check the website to find out if your rule has been entered.
That's a really good point. It's a good point. I mean, they are an agency like like I am and like Ryan's clients are, and people are working their hardest, but sometimes get caught up when you don't have when you're short staffed. Are there any other comments? Anybody want to share an experience that they've had with temporary rulemaking?
And if we don't have any comments, feel free to put it in our question. Happy to entertain that. But one question to wrap us up on is, if either of you have had the experience where you've weighed out, where you've had the situation where the law did not require, there wasn't a shall that you shall write rule, a temporary rule, but the situation where it was sort of option in the sense of not required by law, and where you either lean towards yes, absolutely necessary, or you made the judgment call of no, like just a good example of weighing out that situation.
If I understand your question correctly, you're asking if we didn't have the express authority and pursued it anyway and were challenged by it. Is that your question?
Right, where like it wasn't required by a statute, and just like your thought, where you thought through and you're like, maybe, but maybe you said, like, no, we don't need that, or where you landed of and weighing it, like obviously there's situations where you did because you've done it, but I'm just thinking through, like, as a rules coordinator, where maybe you're negotiating that and like why maybe you decided you didn't need it.
I haven't had that issue, but I'll go back to one of the things we said at the beginning is that the statutory grounds for immediate adoption is one of the two-part question you have to answer. It's not just we've met the statutory grounds, there's been a change in the law. You also have to demonstrate why adherence to the notice and hearing requirements for permanent rulemaking would be contrary to the public interest. So I haven't had the experience where I've been challenged by rules review, meeting that statutory requirement, like a statutory change is easy when you point to the statute, but you need to explain. And this is why we are asking that it be in a shortened process. I haven't had a rule denied, but I did promulgate on behalf of the agency some rule changes through the temporary rulemaking process related to building some private bridges up in the mountains to help, again, relating to general contracting, relating to helping individuals get back into their homes, because a lot of people up in the mountains have to cross bridges, like private bridges, to get onto their property. And there were some questions about that because it wasn't promulgated within 210 days uh, after after the date that some people thought. And I was like, no, we're looking at this date. So I don't know if that's an answer to your question, but yeah, they'll ask the questions. They'll ask, again, it's easy to figure out if there's been a natural disaster or something, but they want to know, why why can't you do it in permanent rulemaking process?
I think Anne put a bit of a response, but I'll expand on it, is that with Charlotte, if you do have that question where you're thinking, well, it might go one way or it might go the other. Do you feel there is reason to create a temporary rule, such as that you need a rule in place more quickly than the permanent rulemaking process? Then it might be worth the effort to go through that temporary rulemaking, because you're also going through the permanent rulemaking. Don't rely on one then the other. Do it at the same time. And if there's a lot of hard questions from RRC on the temporary rule, and they decide, no, you don't have the authority here, or it doesn't meet the circumstance, then you're still in the process with the permanent rule, and at least that's still moving as quickly as possible. But if you identify a need to have it done now, and start that process in getting it done through a temporary rule, then it's probably worth the effort to make it happen.
Ryan, that's a good takeaway. We talked about early on about doing the temporary and then doing the permanent. There is absolutely no prohibition. Matter of fact, quite frankly, I would encourage it to start, if this is a change that you want to keep in place, to start it as close to when you're starting the temporary rulemaking process as possible, so that if you hit a problem with regards to the contrary to the public interest, if you get a lot of pushback on that, well, that's not a piece of permanent rulemaking. So you're already down the road on that, and you at least would not be starting afresh once temporary rulemaking is over.
All right. Well, I want to be conscious of time. Thank you both for spending time with us today and going more in depth on this topic. For all those that are still with us, you will be receiving an email from the Bar Association with a link to the recording. And I also want to note that all of these recordings are available on the section's website, and that's open to all and free to all to review. Please remember that you don't have to be an attorney to join the administrative law section, that our next Rules of the Road is on October 9th. And thank you again for attending. And please feel free to follow up and let us know if this session has been helpful to you, and any other topics. Again, I put it in the chat, the email addresses that you can write as far as if you want to hear other topics in the future. So thank you all again. I look forward to seeing you next time.
Thank you. Thank you, Ryan.